While these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what would happen if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. Now, they make the further argument that the House should only be able to impeach after they exhaust all legal remedies, as if the Constitution says the House shall have the sole power of impeachment, asterisk, but only after it goes to court, in the district court, then the Court of Appeals, and then en banc, and then the Supreme Court, and it's remanded, and they go back up the chain, and it takes years. Why didn't the founders require the exhaustion of legal remedies? Because they didn't want to put the impeachment process in the courts. And you know what's interesting is that while these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Other lawyers, maybe not the ones at this table, but other lawyers for the president are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable. You can't do it. Now, they also made the argument that you'll hear more later on from apparently Professor Dershowitz that, well, abuse of power is not an impeachable offense. It's interesting that they had to go outside the realm of constitutional lawyers and scholars to a criminal defense lawyer to make that argument, because no reputable constitutional law expert would do that. Now they say, oh, the president is very transparent. He may have refused every subpoena, every document request, but he released two documents. The document on the July 25th call and the document on the April 21st call. Well, let's face it. He was forced to release the record of the July 25th call when he got caught. When a whistleblower filed a complaint, when we opened an investigation, he was forced because he got caught. You don't get credit for transparency when you get caught. And what's more, what's revealed in that, of course, is damning. Mr. Cipollone made the representation that Republicans were not even allowed in the depositions conducted in the House. Now, I'm not going to suggest to you that Mr. Cipollone would deliberately make a false statement. I will leave it to Mr. Cipollone to make those allegations against others. But I will tell you this, he's mistaken. He's mistaken. Every Republican on the three investigative committees was allowed to participate in the depositions, and more than that, they got the same time we did. They make the argument the president was not allowed in the Judiciary Committee, chaired by my colleague, Chairman Nadler, to be present, to present evidence, to have his counsel present. That is also just plain wrong. Just plain wrong. I'm not going to suggest you they're being deliberately misleading here, but it is just plain wrong. You've also heard my friends at the other table make attacks on me and Chairman Adler. You'll hear more of that. I'm not going to do them the dignity of responding to them, but I will say this. They make a very important point, although it's not the point I think they're trying to make. When you hear them attack the House managers, what you're really hearing is, we don't want to talk about the president's guilt. We don't want to talk about the McConnell resolution and how patently unfair it is. We don't want to talk about how to pardon the expression, ass backwards it is to have a trial and then ask for witnesses. And so we'll attack the House managers because maybe we can distract you for a moment from what's before you. Maybe if we attack the House managers, you'll be thinking about them instead of thinking about the guilt of the president. So you'll hear more of that, and every time you do, every time you hear them attacking the House managers, I want you to ask yourselves, Away from what issue are they trying to distract me? What was the issue that came up just before this? What are they trying to deflect my attention from? Why don't they have a better argument to make on the merits?